How's it going, everybody? This is Anthony Miranda, attorney with the Firearms Policy Coalition. Today I want to bring to your attention the unprecedented and unsettling decision by the Ninth Circuit en banc Court of Appeals in Young v. Hawaii. Hawaii law requires that residents seeking a license to openly carry a firearm must demonstrate good moral character, that he or she will be engaged in the protection of life and property, and that there is the urgency or the need to carry a firearm. In practice, virtually nobody ever demonstrates a strong enough urgency or need to be issued a license in Hawaii. Therefore, the interplay between Hawaii's statutes and the county's application of them results in an outright bar on individuals obtaining a license to carry a firearm. In 2011, George Young submitted 2 applications for an open carry license. Both of his applications were denied because he failed to demonstrate a sufficient urgency or need for a permit to openly carry a firearm in public. Mr. Young challenged the denials in court, arguing that his desire to carry a firearm for self-defense was all the Second Amendment required. After the district court ruled against him, a 3-judge panel of the Ninth Circuit ruled in his favor. The 3-judge panel held that the Second Amendment must protect some method of carrying firearms outside the home, like open carry, since the Ninth Circuit had previously held that concealed carry is not protected. After the 3-judge panel's decision, the Ninth Circuit decided to rehear the case en banc, which means before an 11-judge panel of 10 randomly selected judges, plus the chief judge. The en banc court limited their analysis to whether individuals have a right to carry weapons openly in public. This is because the Ninth Circuit has already held that individuals do not have a Second Amendment right to carry concealed weapons in public under Peruta v. County of San Diego. Therefore, as the dissenting opinions put it, the question in Young was straightforward. Does the Second Amendment, as originally understood, protect the right of an ordinary, law-abiding citizen to carry a handgun openly for self-defense outside of the home? The en banc majority held in Young that it does not, and that a total ban on carrying a firearm outside the home does not implicate the Second Amendment right to bear arms whatsoever. Instead, the majority determined that because history demonstrates a long-standing tradition in English and American law of government prohibiting certain weapons from entering public spaces as means of providing domestic tranquility and forestalling domestic violence, there is no right to carry openly in public. The majority declared in their opinion that a state may constitutionally forbid all public carry of firearms based on the utterly inconsequential fact that the lawful manner of open carry has historically been subject to modest regulation, but never to outright prohibition. The majority based its decision on the mere fact that there is some historical evidence of regulating the manner in which firearms may be carried in public as a basis to then support a finding that the Second Amendment does not support carrying firearms in public at all. As Judge O'Scanlan put it in his dissenting opinion, today a majority of our court has decided that the Second Amendment does not mean what it says. Instead, the majority holds that while the Second Amendment may guarantee the right to keep a firearm for self-defense within one's home, it provides no right whatsoever to bear, i.e. to carry, that same firearm for self-defense in any other place. The dissent further pointed out that the majority's holding is as unprecedented as it is extreme, and that it reduces the right to bear arms to a mere ink blot. Moreover, the holding undermines not only the Constitution's text, but also half a millennium of Anglo-American legal history. The Supreme Court's decision in District of Columbia v. Heller and McDonald v. City of Chicago, and the foundational principles of American popular sovereignty itself. The majority opinion cited FPC's brief and adopted much of the history it provided. Specifically, FPC's brief proved that firearm carrying was common in colonial and founding eras, and that it was even required by many colonies and states. As the opinion noted, the brief effectively demonstrated a general acceptance by local governments of some firearms in public squares. But the court nevertheless held that the Second Amendment does not protect such carrying in public. Through its opinion, the en banc court makes the Ninth Circuit the first and only court of appeals to hold that public carry falls entirely outside the scope of the Second Amendment's protections. This decision has immediate implications for states like California, Oregon, Nevada, Arizona, Idaho, Montana, Washington, and Alaska, which are all within the jurisdiction of the Ninth Circuit. These states now have circuit authority through Young and Peruta to support prohibiting the carrying of firearms openly in public and or also concealed. The Supreme Court considered whether or not to hear a different carry case at its March 26th conference. That case is New York State Rifle and Pistol Association v. Bruin, which involves a challenge to New York's severe carry restrictions. FPC has also filed a brief in support of plaintiffs in Bruin as well. So if you are outraged by the Ninth Circuit's recent decision in Young, please head on over to joinfpc.org and join us in fighting back against state bans on carrying of firearms in public. Your donations go directly to helping our team fight against these two infringements with our lawsuits on carrying in New York, New Jersey, Pennsylvania, and a number of others that we are currently working on getting off the ground. Once again, this is Attorney Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.